Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we have another installation for the Anti-Federalist Papers series going on number 24. So if you haven't gone back and watched 1 through 23, I would highly encourage you to do so because understanding the Anti-Federalist Papers, in addition to the Federalist Papers, will provide you a very well-rounded, very advantageous understanding of the U.S. Constitution, and understanding the U.S. Constitution thoroughly will be absolutely necessary to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. Like I said, we're going on to number 24. There are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both just in case you can't access one or the other for whatever reason. If you haven't already, go ahead and pick up a copy of the Federalist Papers while you're out there looking. That way you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 24 is titled Objections to a Standing Army, Part 1, written by Mr. Brutus. Now, this one's going to directly contrast, I think it was number 45, Federalist number 45. It was the one written by Mr. Madison where he had said, the U.S. Constitution by no means grants the federal government any power to have a standing army. He said, in fact, if it does come about that a standing army, that an ambitious government tries to raise a standing army, that the citizens of the states and the states have an obligation, are duty-bound to resist physically and diplomatically that standing army. That it would be a 1 to 10 ratio in terms of the standing army's numbers compared to the able-bodied citizens who are duty-bound to resist that standing army. The author, well, some like to dispute the penmanship of Madison or his influence in the final draft of the U.S. Constitution. So we'll go with father of the Constitution. The father of the Constitution said that. So let's see what Mr. Brutus had to say, what his concerns were in 1788. So the first essay is taken from the 9th letter of Brutus, which appeared in the New York Journal, January 17th, 1788. He says this: standing armies are dangerous to the liberties of the people. Almost verbatim what Madison said. If necessary, the truth of the position might be confirmed by the history of almost every nation in the world. A cloud of the most illustrious patriots of every age and country where freedom has been enjoyed might be adduced as witnesses in support of the sentiment. But I presume it would be useless to enter into a labored argument to prove to the people of America a position which has so long and so generally been received by them as a kind of axiom. Some of the advocates for this new system controvert this sentiment, as they do almost every other that has been maintained by the best writers on free government. Others, though they will not expressly deny that standing armies in times of peace are dangerous, yet join with these in maintaining that it is proper the general government should be vested with the power to do it. That's a scary position. They know it's dangerous, but advocate for it anyway. I shall now proceed to examine the arguments they adduce in support of their opinions. Every argument is for safety, prioritizing safety over liberty. And what did Thomas Jefferson and Benjamin Franklin say about that? Those who prefer safety over liberty, or freedom, safety over freedom, deserve neither and will get neither. A writer in favor of this system treats this objection as a ridiculous one. Wonder who that was. He supposed that it would be as proper to provide against the introduction of Turkish Janissaries or against making the Alcoran rule of faith. 1. A citizen of America, Noah Webster, an examination into the leading principles of the federal constitution proposed by the late convention held at Philadelphia. With answers to the principal objections raised against the system, Philadelphia 1787, reprinted in Ford.ed, pamphlets, pages 29 through 65. From the positive and dogmatic manner in which this author delivers his opinions and answers objections made to his sentiments, one would conclude that he was some pedantic pedagogue who had been accustomed to deliver his dogmas to pupils, who always placed implicit faith in what he delivered. But why is this provision so ridiculous? Because, says this author, it is unnecessary. But why is it unnecessary? Because, quote, the principles and habits as well as the power of the Americans are directly opposed to standing armies, and there is as little necessity to guard against them by positive constitutions as to prohibit the establishment of the Mahometan religion. It is admitted, then, that a standing army in time of peace is an evil. I ask then, why should this government be authorized to do evil? If the principles and habits of the people of this country are opposed to standing armies in time of peace, if they do not contribute to the public good, but would endanger the public liberty and happiness, why should the government be vested with the power? No reason can be given why rulers should be authorized to do what, if done, would oppose the principles and habits of the people and endanger the public safety. But there is every reason in the world that they should be prohibited from the exercise of such a power. But this author supposes that no danger is to be apprehended from the exercise of this power, because if armies are kept up, it will be by the people themselves, and therefore to provide against it would be as absurd as for a man to, quote, pass a law in his family that no troops should be quartered in his family by his consent. This reasoning supposes that the general government is to be exercised by the people of America themselves. But such an idea is groundless and absurd. I like that. But such an idea is groundless and absurd. There is surely a distinction between the people and their rulers, even when the latter are representatives of the former. They certainly are not identically the same, and it cannot be disputed, but it may and often does happen that they do not possess the same sentiments or pursue the same interests. I think I've shown in a previous paper that as this government is constructed, there is little reason to expect that the interest of the people and their rulers will be the same. Besides, if the habits and sentiments of the people of America are to be relied upon as the sole security against the encroachment of their rulers, all restrictions in constitutions are unnecessary. Nothing more is requisite than to declare who shall be authorized to exercise the powers of government. And about this we need not be very careful, for the habits and principles of the people will oppose every abuse of power. This I suppose to be the sentiments of this author, as it seems to be of many of the advocates of this new system. An opinion like this is as directly opposed to the principles and habits of the people of America as it is to the sentiments of every writer of reputation on the science of government, and repugnant to the principles of reason and common sense. The idea that there is no danger of the establishment of a standing army under the new Constitution is without foundation. You can see I already have it highlighted. Go ahead and highlight it for yourselves. I would highlight it again, but I'm afraid it'll make it ineligible. Here, I'll do it and then undo it, just so you are encouraged to join me in doing it. Oh, and it's still legible. Never mind. Scratch that thought. Back to Brutus. It is a well-known fact that a number of those who had an agency in producing the system, and many of those who it is probable will have a principal share in the administration of the government under it, if it is adopted, are avowedly in favor of standing armies. It is a language common among them, quote, that no people can be kept in order unless the government have an army to awe them into obedience. It is necessary to support the dignity of government to have a military establishment. And there will not be wanting a variety of plausible reasons to justify the raising one, drawn from the danger we are in from the Indians on our frontiers, or from the European provinces in our neighborhood. If to this we add that an army will afford a decent support and agreeable employment to the young men of many families who are too indolent to follow occupations that will require care and industry, and too poor to live without doing any business, we can have little reason to doubt but that we shall have a large standing army as soon as this government can find money to pay them, and perhaps sooner. Highlight that entire sentence. It's a little bit of a run-on, a little bit of a mouthful, but so incredibly important. As soon as the government will have money to raise a large standing army, there will be one. Lo and behold, not even, what would that be? So 1789, the U.S. Constitution is officially implemented. And then I think it was 1794, 1795, you have the Whiskey Rebellion, where 10,000 troops, 10,000 Union troops were sent to coerce 500 Pennsylvanians to pay a tax that was unrepresentative, unconstitutional, and abusive. A writer who is the boast of the advocates of this new Constitution has taken great pains to show that this power was proper and necessary to be vested in the general government. He sets out with calling in question the candor and integrity of those who advance the objection, and with insinuating that it is their intention to mislead the people by alarming their passions rather than to convince them by arguments addressed to their understandings. Yeah. I mean, we're getting really close to the ending of the Federalist Papers, and just every single time Hamilton publishes a paper, it's always, well, competent men would be able to comply with, well, reasonable people understand that, well, men of intelligence and wisdom and good moral virtue would understand. He does it every single time. He's so pompous and so derogatory. The man who reproves another for a fault should be careful that he himself be not guilty of it. Oh, there's a tidbit of wisdom not applicable just to government, but to all of life. How far this writer has manifested a spirit of candor and has pursued fair reasoning on this subject, the impartial public will judge when his arguments pass before them in review. He first attempts to show that this objection is futile and disingenuous because the power to keep up standing armies in time of peace is vested under the present government in the legislature of every state in the Union except two. Now, this is so far from being true that it is expressly declared by the present Articles of Confederation that no body of forces, quote, shall be kept up by any state in time of peace, except such number only as in the judgment of the United States in Congress assembled shall be deemed requisite to garrison the forts necessary for the defense of such state. Now, was it candid and ingenuous to endeavor to persuade the public that the general government had no other power than your own legislature have on this head, when the truth is your legislature have no authority to raise and keep up any forces? He next tells us that the power given by this Constitution on this head is similar to that which Congress possess under the present Confederation. As little ingenuity is manifested in this representation as in that of the former. I shall not undertake to inquire whether or not Congress are vested with the power to keep up a standing army in time of peace. It has been a subject warmly debated in Congress more than once since the peace, and one of the most respectable states in the Union were so fully convinced that they had no such power that they expressly instructed their delegates to enter a solemn protest against it on the journals of Congress should they attempt to exercise it. But should it be admitted that they have the power, there is such a striking dissimilarity between the restrictions under which the present Congress can exercise it and that of the proposed government that the comparison will serve rather to show the impropriety of vesting the proposed government with the power than of justifying it. If you haven't gone and watched the series or the lecture, I think it was a singular lecture, that we've done on the Articles of the Confederation, please do so now, because the contrast between the powers allotted to the Confederated Congress were significantly fewer and were significantly less binding than the powers that were allotted and implemented, imposed, never ratified, imposed by the U.S. Constitution. That lecture, the one on the Articles of Confederation, will provide plentiful explanation as to what Brutus is speaking to here. It is acknowledged by this writer that the powers of Congress under the present Confederation amount to little more than that of recommending. If they determine to raise troops, they are obliged to effect it through the authority of the state legislatures. This will, in the first instance, be a most powerful restraint upon them against ordering troops to be raised. But if they should vote an army, contrary to the opinion and wishes of the people, the legislatures of the respected states would not raise them. Besides, the present Congress hold their places at the will and pleasure of the legislatures of the states who send them. That's exactly right. The state legislatures could recall their representatives and their delegates at any time, for any reason, who send them, and no troops can be raised but by the assent of 9 states out of the 13. Compare the power proposed to be lodged in the legislature on this head, on this head under this Constitution, with that vested in the present Congress, and every person of the least discernment, whose understanding is not totally blinded by prejudice, will perceive that they bear no analogy to each other. Under the present Confederation, the representatives of 9 states out of 13 must assent to the raising of troops, or they cannot be levied. Under the proposed Constitution, a less number than the representatives of 2 states in the House of Representatives and the representatives of 3 states and a half in the Senate, with the assent of the President, may raise any number of troops they please. The present Congress are restrained from an undue exercise of this power. From this consideration, they know the state legislatures, though whose authority it must be carried into effect, would not comply with the requisition for the purpose, if it was evidently opposed to the public good. The proposed Constitution authorizes the legislature to carry their determinations into execution without intervention of any other body between them and the people. The Congress under the present form are amenable to and removable by the legislatures of the respective states and are chosen for 1 year only. The proposed Constitution does not make the members of the legislature accountable to or removable by the state legislatures at all. They are chosen, the one house for 6 and the other for 2 years, and cannot be removed until their time of service is expired, let them conduct ever so badly. The public will judge, from the above comparison, how just a claim this writer has to that candor he asserts to possess. In the meantime, to convince him and the advocates for the system that I possess some share of candor, I pledge myself to give up all opposition to it on the head of standing armies, if the power to raise them be restricted as it is in the present Confederation. Listen to that concession. Brutus is saying, if y'all just put one restraint, one prohibition on the raising of standing armies, I'll rescind all my other objections. But because that ability, that authority, that avenue stands, my other objections remain. And I believe I may safely answer, not only for myself, but for all who make the objection, that they will not be satisfied with less. So if you have any questions about what Mr. Brutus was saying there in number 24, maybe questions about what was said in the preceding papers, or if there's a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments below, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, bid you all farewell.